Hi class. In this video, I'll be going over Chapter 3 on law and the legal system. Now, obviously, law is a very important aspect of our country, and its primary purpose is really to function as the main tool with which we organize ourselves as an advanced and democratic society. Now, it can be somewhat of a complex area to study, and all of you do have a basic understanding of how our legal system works from current events that have been reported in the news. So just so we don't really go over things that you may already be familiar with, in this chapter, we're really going to start with the core points of our legal system here in the U.S. And the importance of this background information will become clear to you as the chapter goes on. Of course, make sure that you do take the time to read the chapter. But I'm going to jump to slide number 3 on the role of law. All right? Okay, so law reaches into nearly every corner of American life, right? It impacts us all day long. There are laws that pertain to the safety of cars, buses. We have consumer protection laws. I mean, there are so many different types of laws that are in place to protect us as a society. And the truth of the matter is that a society that is as sprawling and complex as ours needs formal, enforceable rules of law to provide a measure of control. I mean, the truth of the matter is that, if you pick up a newspaper or you're going through your news app or Googling different topics or issues going on locally or on a national level, there's always some type of legal angle that's included in the article you're reading. So it really does have this impact on our everyday activities, and it is definitely a way to make our country a safer place to live. All right, let's go to slide 4 for a moment. So the main way the law governs the many kinds of relationships in society is really to organize and establish enforceable legal rights and to create institutions necessary to define and enforce them. Now, a legal right denotes a power or privilege that has been guaranteed to an individual under the law, not merely something that's claimed as an interest or something that's a matter of governmental discretion. So here I've noted that when you consider law, that you should consider law as a system which entails regularly interacting and independent parts and some subparts coming together to form a functional, unified whole. All right, so now for the sources of law. So regardless of how law is defined, at the core of the legal system lays a body of enforceable written rules. And the laws from both the federal and state legal systems stem from 3 primary sources. We have Constitution, statutes, regulations, and common law. Now, when we're talking about constitutions, they tend to be relatively small in number, but they're very important because they protect rights that as a society we have found to be fundamentally important. So the right to be free from unreasonable searches and seizures is one such important right. So a constitution is really a charter that both establishes a government and delineates fundamental rights and obligations of that government and of individuals who fall within the territory covered by the Constitution. So in our country, there is the federal Constitution that tends to be rather shorter, for the most part, quite general. And the whole idea was that the framers of the Constitution viewed it as a document for the ages that needed to include enduring principles to serve a growing, evolving society that has certainly proved to be more complex than it was at the time of the Constitution's ratification. And then we also have our state constitution. So each state has their own constitution. So now regarding statutes, we have in both the federal and state legal systems the legislative branch of government that creates the law by enacting statutes that govern the rights and duties of the people who have the requisite minimum contacts within that jurisdiction. So, as defined in the book, statutes are really laws written by legislative bodies, again, at all levels. And they command or prohibit something. It is the fact that they're being legislatively created that sets them apart from other sources of law, because legislators are understood as creating laws that are forward-looking and apply to large numbers of people. Now, although legislators enact these statutes, they also authorize agencies to issue regulations that help interpret and clarify what a statute means. So an example would be Title VII, which is a statute that makes it illegal for employers to discriminate against their employees on the basis of their race, religion, gender, or their place of birth. So Congress also gave a federal agency the authority to implement regulation and guidelines to help interpret this statute and give it this practical effect. Okay? So just to kind of give you an idea of where that is coming from. Now, regarding regulations are more specific, and they must be written to really assist with the implementation of statutory directives and to promote statutes' underlying policy goals. So this is where the administrative agencies of the executive branch of the government come in, because these federal and state agencies, such as the U.S. Department of Health and Human Services, the U.S. Department of Labor, are organized and created to deal with a specific policy's subject matters. They have more time and expertise than Congress or state legislators to really enforce statutes. And last, I want to very briefly touch on common law. So some laws don't have their source in a constitution or statute. Instead, these laws evolve solely from court decisions, and they are called common law. Now, you might be wondering how these common laws evolved. Judges started from a few basic ideas that seemed to be universally accepted in the medieval society. As new factual controversies arose, the judges expanded on and refined their interpretations of the common law by focusing on the similarities to and distinctions from previous cases. So, although common law really originated in England, it was brought to the U.S. by the British colonists, eventually becoming each state's original body of law. Now I'm going to touch on the key features of the legal system. So, the American Constitution, as mentioned in our chapter, was created in 1789 and is one of the most distinctive features of our American legal system. It made a clear distinction between the various branches of government and their respective jurisdictions. This separation of powers provides a system of shared power which acts as checks and balances between the various branches of the government. So we have these three branches of the government which were created in the Constitution, which we've touched on in this class. We have the legislative, the executive, and the judiciary. Now, each of these branches has certain powers, and each of these powers are limited. All right, so an example of this would be when the president appoints judges and departmental secretaries. But these appointments must be approved by the Senate. The Congress can pass a law, but the president can veto it. So the Supreme Court can rule a law to be unconstitutional, but the Congress with the states can amend the Constitution. So really the separation of federal and state powers remains one of the most distinctive features of the American legal system. Now, among the nations that have been steady democracies since the end of World War II, we have the U.S. that's been one of the few countries that has a chief executive who is elected independently of the legislature and is not in any meaningful way accountable to the legislative branch. So while the U.S. has always used this presidential model of government, very few other countries with stable, enduring democratic systems have done so. So instead, over history, most other countries, such as France or Germany, have adopted more of a parliamentary model of government, whereby the chief executive is accountable to the legislative branch, rather than independent of the legislative branch. All right, so I just want to make sure that you guys understand that. I'm going to repeat it one more time. Now, instead, over history, most other countries, as I said, such as France and Germany, have adopted more of a parliamentary model of government. So this is where the chief executive is accountable to the legislative branch. But here in the U.S., the chief executive is independent of the legislative branch. And I just want to make sure, I know I went through that, I hope not too quickly, but the legal doctrine that really supports the arrangement of the shared governance among multiple branches is the separation of powers. And in this doctrine, it's considered that it is one of the most important aspects of both the federal and state constitutional design. Now, the framers of the U.S. Constitution were well aware that nothing was more likely to foster tyrannical government than the concentration of governing powers in one individual or political party. So the whole idea was to guard against this concentration of political power. The framers did two related things. They divided the governmental powers and responsibilities among separate, co-equal branches, and they structured the elections of officials for the two political branches of government, being legislative and executive. And as I explained, that they're separated. Okay? Now, when we're talking about federalism, in federalism, the powers are divided between the federal and provincial governments. So we're talking about federal and state legal authority. Now, there's no uniform method for the distribution of powers, but the general and basic principle here is that matters of local importance are given to the state, and those of national importance are given to the government. And the aim behind this method is really to keep the center weak and the provinces strong. Now, another key feature of our legal system is the role of the courts. And courts have the responsibility to really determine what the Constitution means, what it permits, and what it prohibits. And courts protect and enforce individual legal rights. They determine whether the political branches of government have violated the Constitution. And they really maintain stability in the law through the application of legal precedent. Now, courts are expected to uphold and enforce the constitutional right to due process, which protects individuals from arbitrary and unfair treatment at the hands of the government. Now, when talking about our court system, our federal court system, the federal court system really that we have today is not the same system that was created by framers of the Constitution. It really has grown and evolved over time. So the federal court system has it's organized in 3 tiers or 3 levels, and then we have the trial courts, the appellate courts, and the Supreme Court. I included the definitions here on this slide so you have a better idea of exactly what each one, what it is and what their responsibilities are. And of course, you do need to read the chapter to really understand the different aspects of the U.S. legal system. If you have any questions, don't hesitate to let me know. That's what I'm here for. And that pretty much wraps it up. Take care. Bye.